Hi, everyone. Welcome to Crime in Court. This is the Canton Cover Up Series Commonwealth versus Karen Reed Trial 2.0. And we are in the middle of jury selection, it just began on Tuesday, so April 1st, this past week. There have been a lot of filings that we need to go through, a lot of updates. I'm sure I'm going to miss some, but I'm going to try to get through as much as we possibly can in this short amount of time. So, up first, I'm going to give you just a quick little update of what happened via jury empanelment. They had on Monday through Friday, or sorry, Tuesday through Friday of this week, they had potential jurors coming in. Eventually, and at the end of the week, they have now 10 jurors selected. So the goal is 16. They want 12 jurors and 4 alternates, basically similar as last time. So that's kind of where we're at. I'm a little surprised how fast the jury empanelment is going, but especially for a high profile case like this. But you know what? Cool. The faster we can get this underway, the better, so that Karen Reed can get back to her normal life. As whatever that is now, her life is never going to be normal again, but you know what I mean. All right. So, like I said, we have a lot of filings. Many of them are short, so hopefully this doesn't take too long to get through all of them, but there are a lot. So I just want to give you fair warning. Let me shrink myself here. Please hit that like button so we can get started. All right. So this up first, we're going to go through the jury questionnaire. So, like I said, jury empanelment is underway. That will go as long as it needs to until they have their 16 jurors, and then I'm sure opening statements and jury instructions and all of that stuff will happen soon after their 16 are selected. So let's get started here. This is the actual jury questionnaire that was used. So we went over on my channel, we went over a jury questionnaire. Those were the proposed jury questions. And then they were discussed at a hearing. And then this is what actually is the questionnaire that the juries are going to see. So, number one, it is alleged that on January 29th, 2022, while intoxicated and operating her motor vehicle in Canton, the defendant, Karen Reed, took the life of her boyfriend, John O'Keefe, an off duty police officer, Boston police officer. Is there anything about the description in this case, the charges, or that the victim was an off duty police officer that causes you to believe that you cannot be fair and impartial? I believe that was the same question as before. Second question, have you already started to make up your mind about this case? Number three, do you have any opinions regarding previous experiences as a juror, the fairness of the jury system or criminal justice system in our country that would impair your ability to be fair and impartial to both the Commonwealth and to the defendant? Do you have any religious or philosophical beliefs that would make it difficult for you to follow the law and to come to a verdict in this case? This case is expected to garner a significant amount of media attention. Is there anything about the high profile nature of this case that would prevent you from serving as a fair and impartial juror? Do you, any family members, or close friends reside in or conduct regular business in Canton, MA? If the testimony were in conflict, would you tend to believe the testimony of the police officers more than the other witness simply because the witness is a police officer? This, I believe, they did reword the question to make it believe and disbelieve, which I think it sounds better that way than how it had been originally worded. So I like this question better. Conversely, would you tend to disbelieve an officer simply because the witness is a police officer? After following the cases that I've been following, my answer here would be yes. So I would not be able to be on this jury. Do you believe that law enforcement officers are generally fair and accurate in their investigations? Do you have any strong personal beliefs, or have you been exposed to any strong personal beliefs from friends and relatives about law enforcement officers, prosecutors, or the government? Have you ever been involved in a group, community, or individual activity showing support for law enforcement in or outside your community? Have you ever been involved in a group, community, or individual activity that was critical of the police or law enforcement? Like, are you protesting Michael Morrissey, or are you protesting in support of police, whatever? Have you done anything in regards to supporting law enforcement or been critical of law enforcement? I like that they do both ways around, both versions of that question. Have you or someone close to you ever had education, training, or work experience in any of the following fields: law enforcement, military, alcohol, drug abuse, domestic violence? Do you have any strong personal beliefs, or have you been exposed to any strong personal beliefs from friends and relatives about operating a motor vehicle under the influence of alcohol? And this needs to be hammered home, this question, but the attorneys aren't able to ask questions. Judge Canoni denied the attorneys the opportunity to do a attorney jury, you know, review. So basically, Canoni asks the question. She vets out each and every single juror. So is she asking the proper questions? Is she asking all the questions that the defense would want? I'm sure no. And I'm sure she's not asking or looking for the same things that the defense is looking for in a juror. So how is this even fair when they wanted to be able to question the jurors? But they can't. And this question, I really hope people are being truthful in their questionnaire. Have you ever been involved in group organization, and participated in a march, demonstration, campaign, or donated money on behalf of an organization or cause that was against drunk driving under the influence of alcohol, such as SAD, Students Against Drunk Driving, or MAD, Mothers Against Drunk Driving? That's a good question. I think that might have been asked the first time around. A lot of the questions are similar from the first trial. Has anyone close to you been involved in an incident involving drinking and driving? If so, would that experience prevent you from being fair and impartial juror in this case? Would or have you or has anyone close to you been involved in or witnessed a motor vehicle crash? Is there anything about crash reconstruction testimony that would make it difficult for you to be fair or impartial in this case? Um, That's an odd question. Like, what about crash reconstruction would make it difficult for me to be not fair? That's an odd question to me. Have you or any family members or close friends been involved in a domestic violence relationship that featured physical, mental, and or verbal abuse? Since they're claiming that Karen is supposedly abusive or was abusive of John, which I think they were both kind of equally, I wouldn't say abusive, but they didn't treat each other the nicest. So I don't know. Have you ever been a victim of a violent crime? During trial, you will hear testimony about medical treatment, death, and review graphic autopsy photographs. Will that affect your ability to participate and be a fair and impartial juror? Do you believe Karen Reed should have to prove her innocence? That's a good question because a lot of people still believe that defendants have to prove their innocence. If the defendant doesn't testify do you think that she is probably guilty of hiding something? Do you know or recognize anyone that you have seen today in the courthouse or in the jury pool? Speaking of the jury pool, there was someone on Friday who was in the jury pool, and he had his phone with him, and he was taking pictures of like his point of view from the courtroom from selection where they were watching a video, and then he also took a video. So that was a photo of like the backs of other jurors' heads. And then he took a video walking into the courtroom with a bunch of other potential jurors, seeing again the backs of other potential jurors' heads. So that's another thing that happened this week, and I'm sure that that juror, and he was posting it to Facebook. That's how he was caught. So he was posting it to Facebook, and I don't know what's going to happen to him. I'm sure he was excused. Would your answers to any of the above questions be embarrassing or damaging if disclosed publicly, or would disclosure infringe on your privacy? Do you have any problem like vocalizing your thoughts here? Do you have any concerns about your personal privacy due to the presence of video cameras in the courtroom and or a highly publicized nature of the case? Do you have any knowledge of the case gained from any source? And if so, what are your sources? You've got television, radio, newspapers, magazines, internet, Twitter or X, social media, other social media, select one, podcast. That's interesting that Twitter is separate from uh, the other social medias. Media, media is also plural. Podcasts, family, friends, observations in the community, overheard discussions, or other. How, tell us how have you gained any information? What was the source? What are the details of the case that you are able to recall? So if you heard something, what did you hear? And be specific. Are you aware of any specific impact this criminal allegation has had on your community? What is your primary source of news and information? How often do you read print or online newspapers, magazine, blogs, or other sources? How often are you exposed to news from radio, television, podcasts, or other social media? And what sources? What is your familiarity with a case prior to today? Have you had discussions about this case prior to today? Is there any reason you would be unable to follow an instruction that during your jury service you may not read any news or media accounts about this case, watch or listen to any media or news broadcasts or commentary about this case, discuss this case with anyone, research or look this case up on the internet, or perform independent research? Is there that would be the hardest part for me, is to not do my own independent research on things that I learned in the case. That would be the hardest thing. Like, "Oh, they said that. What is that?" Like I'd want to go and like learn everything about like what the expert witness was talking about or whatever. Like I'm the type of person where I like to go out and learn. So, if that were if I ever had been picked for a jury, which I'm never going to. First of all, I'm disabled. Second of all, I do this, so I'm not going to be picked. But that would be the number one hardest thing for me. Like I could deal with not talking about it, not avoiding. I could avoid it on the news and whatever. But the whole not being able to research my own stuff, that would be the hardest for me, at least. I don't know. Just out of curiosity, you guys, what do you think would be the hardest part of being on a jury? Especially like a 10-week jury like this where you can't talk about it. It's a high profile case. What would you think is the hardest part? All right, and finally, we've got two last questions here. It says, is there any reason you would be unable to follow an instruction that during your jury service you may not read or view any social media articles, posts, videos, podcasts, or other non traditional media platforms that may discuss this case? And is there any reason that if you are inadvertently exposed to extrajudicial influence or media about this case, you would be unable to follow an instruction that you must report an exposure to the court officer? So if you are exposed to something, would you be able to immediately tell on yourself, basically? So that is the jury questionnaire. Let's move on to we have a bunch of orders that came in this week from Judge Canoni, or as many people are calling her, Kim Jong Canoni. She's I think I personally, I don't know if this is true or not, but I personally feel that after she was told that the federal investigation has ended, she's kind of been more emboldened to deny things for Karen Reid. She's been more emboldened be um to show her bias. I'll say that. A lot of lawyers are like, well, she's not corrupt, whatever. She's corrupt, in my opinion. But she's blatantly showing her bias, which I think makes her corrupt too. So there's that. So here is the memorandum of decision and order of the Commonwealth's motion to appoint court stenographer, prevent identification of jurors, and impound jury names during the trial. The Commonwealth has moved for the court to 1. Appoint a stenographer, 2. Impound the names of all jurors, 3. Impound all sidebar conferences, and 4. Prohibit spectators and journalists from attempting to provide specific identifying information of jurors or potential jurors to the public. This was like all, whoa, what? No, jurors can't talk about journalists can't talk about the jurors. That's only partially true. Like people, once jury selection started and people were reporting, like, here's a man or a woman going up, people were like, "Oh, that's breaking this order," but it's actually not. Like they got guidance. They can talk about race, gender, basic things, but they can't be like, "Well, this person was wearing this and that and blah blah blah." So they can talk about, general demographics, but they can't talk about, anything that would identify the jurors to the public. So a court reporter has been ordered and will be responsible for the entire trial record, though the courtroom proceedings are recorded on the court's recording system for the record. FTR is what it's called, for the record. The sidebar conferences will not be available in the for the record software until after the trial has concluded. Number 2, this case has garnered significant and divisive attention in Massachusetts and across the country. Individuals associated with this case have been charged with intimidation, with charges remain pending. At least, which charges remain pending for Turtle Boy, is what they're saying, for the witness intimidation. At least, or is what Bev is saying. At least one deliberating juror from the first trial submitted an affidavit to the court detailing reasonable fear for the safety of their family should the list of jurors be made available. That was the guy who was the foreman who prevented other jurors from asking questions and getting clarification about a split verdict, which ultimately led to a hung trial. So that might be why he's in fear. Preemptively, he was in fear before anybody realized that that's what he did. So maybe that's why he didn't want his name coming out, is because he was the one that was preventing other jurors from getting clarification from the judge about what to do with a split verdict. This court concludes that the fear expressed by the juror, coupled with the inordinate amount of public attention to this trial and its outcome, is good cause to impound the clerk's list of jurors for Norfolk County Courthouse for the duration of impanelment. Further, this court concludes that that good cause exists to impound the list of seated jurors until at least the conclusion of the trial. Impounded upon finding of good cause. Juror lists impounded upon finding of good cause. Sidebar number 3, sidebar conferences will not be available on the FTR. Number 4, spectators and media are prohibited from attempting to provide specific identifying information. Like I said, they can still do general demographic type descriptions. So, but no specific identifying information of the jurors or potential jurors to the public, including physical descriptions of the jurors. So you can't say like this guy was 5'5" and he, bald and glasses and you know, whatever. You can't say those kinds of things, I'm sure. And that is so ordered. What else do we have? Up next, decision and order on defendant's motion to exclude testimony of the witness, Dr. Judson Welcher. And in alternative, the request for voir dire. How do you think she ruled on this? She hasn't been very fair in her rulings lately. She's been pretty um, heavy-handed on the defense, as you'll see as we go through these, and not so nice to the defense, and very, very easy breezy for the Commonwealth, which is driving me and many other people watching this case up a wall. So, after review of the parties' submissions and consideration of the five Daubert-Lanigan factors, the court concludes that there is no reason to preclude the testimony of Dr. Welcher outright. Dr. Welcher has the requisite education, training, experience, and familiarity with the subject matter to qualify him as an expert, and his report demonstrates that methodology or theory underlying the expert testimony is sufficiently reliable to be presented for the jury's consideration. The defense raises several challenges to specific slides provided by the Commonwealth in support of Dr. Welcher's anticipated testimony. Dr. Welcher's expert report accompanying slides, however, indicates the information and methodology relied upon in forming his opinion, to the extent that the Commonwealth seeks to elicit evidence that the defendant believes is beyond the witness's field of expertise, is not supported by methodology that is commonly accepted in the relevant scientific technical community, or relies improperly on witness statements. Defense counsel can object to the line of questioning at trial. Well, this doesn't help, because if you're still letting someone in to testify on something that they're not an expert in, which they weren't, if you went back and read, I think it was Alessi who made the argument, I can't remember, um, that they didn't use the proper methodology, testing, all that good stuff. Sorry, my dishwasher's going off if you can hear that. It's done. So, yeah. So he is the guy, Judd Nelson, or not Judd Nelson. That's Breakfast Club. Judd Welcher is the um, biomechanical whatever. I pulled up his thing here. What is it? He's a biomechanical engineer and accident reconstructionist from the company Aperture, which the Commonwealth got a bunch of their witnesses from Long Beach, California. So he's taught classes in areas of accident reconstruction, biomechanical engineering for Texas, and A&M Engineering Extension. Dr. Welcher has been an accredited accident reconstructionist through the Accreditation Commission for the Traffic Accident Reconstructionists. He's performed and analyzed over 1,000 staged, instrumented human volunteer crash tests and authored over 45 technical publications and presentations on collision trauma. Okay, so that's all fine and good and everything, but he doesn't define his methodology. And we went through the filing from the defense in a previous stream where they went through all of the reasons why he should be excluded. So he doesn't even his methodology doesn't meet the standard. So he might be an accident reconstructionist, but the methodology that he's using, it's not outlined in any way, shape, or form tied to certain other studies that are accepted within the industry. He might as well just be, throwing spaghetti at the wall and thinking that that is how you do it. So they go through in the defense's motion, they go through all of it and break it down. So we're not going to go through that again, but I just wanted to remind you who he was. So there you have it. The judge believes that he's okay to come in, even though his methodology doesn't match anything or tie in any way to some kind of methodology that is generally accepted in the industry. And he's I I don't know why she continues to do this because there's been so many filings, so I can't keep track of them. But she just continues to deny the defense and allow the Commonwealth to get whatever they want, basically. Except for the only good thing she's done so far for Karen is to not allow Hank to get Karen's um, communications with David Yannetti, because that was really reaching. All right, let's move on now to the memorandum and decision in order on the Commonwealth's motion in limine to preclude the defendant from raising a third party culprit defense. So this is they said specifically in court, I believe it was Alan Jackson who was like, we're naming Brian Higgins, Brian Albert, Colin Albert as the three as three of the third party culprits. They laid it out in a motion, and now here's her order. So she says the Commonwealth has moved to preclude the defendant from raising a third party culprit defense. The defendant has alleged three potential third party culprits: Brian Albert, Brian Higgins, and Colin Albert, or Colin Albert, depending on who's saying his name. For the reasons that follow, the Commonwealth's motion is allowed in part and denied in part. This just is one baffling ruling to me, but here it goes. So, the opportunity to present third party culprit evidence is guaranteed by the Due Process Clause of the 14th Amendment because it is rooted in the right of criminal defendants to a meaningful opportunity to present a complete defense. A defendant may introduce evidence that tends to show that another person committed the crime or had the motive, intent, and opportunity. Those are the three things needed to potentially say that someone else did it. However, the defendant's latitude to introduce such evidence is not boundless. The defendant's ability to mount a third party culprit defense is not without limits. Evidence that a third party committed the crimes charged against the defendant or had the motive, intent, and opportunity to commit the crimes is admissible provided that it has substantial probative value and will not tend to prejudice or confuse the jury. Proffered evidence must have a rational tendency to prove the issue the defense raises, and the evidence cannot be too remote or speculative. Now she's going to list them all out one by one. Colin Albert. As to Colin Albert, the defendant's proffer contains no additional evidence than that presented at the first trial, and it is insufficient to support a preliminary finding that Colin Albert had the motive, intent, and opportunity to commit the crime. This is wild. The evidence of opportunity is wholly inadequate. That's for the jury to decide, woman, not you. But okay. She says there is no evidence that Colin Albert was at 34 Fairview when the defendant was and Mr. O'Keefe arrived at the home. So now she's saying that she's the finder of fact, not the jury. That's for the jury to decide if Colin had the opportunity, if Colin was there. That's for the jury, not for her. But here she goes making facts that are definitely contested facts within the trial. But she's just siding with the Commonwealth and stating it as a fact. So, if you didn't think she was biased before, here you go. Third party culprit evidence properly excluded where there was no evidence third party had means or opportunity to commit crime, and evidence of motive was speculative and too remote. Speculative and too remote. Let's talk about that. And it had the means. So if Cullen was there, he definitely had the means to commit the crime. It wasn't too remote because he would have been there at the time. This is not too remote in time. It was time of the crime. And if even if he did leave at 12:15 or whatever time he says he left, that is still very close in time to when John's Apple Health and phone data stopped moving, which was like 12:29 or something, or 12:32 it might have been. So how is that not close in time? So if the possibility of him being there in the house, if it's even possible that he was there at the time when Karen Reed dropped him off, um, this argument just doesn't even fly with me. But that's how Judge Canoni sees it. Evidence at the first trial that Colin Albert had already been picked up by the time that O'Keefe and the defendant arrived. That's not true. She's talking about a unverified text message from Caitlin Albert to Colin Albert that looks very sketchy at best. There's commas and periods and things in the timestamps of the screenshots. It's a screenshot. It's not metadata. It's not like a report from Cellbrite or something. It's a screenshot. How did that even get in? Like, how did this is where we're at. That it never should have come in like the way that it was. Judge Canoni just allowed it in as is. She's like, sure, I believe everything from the Commonwealth. God, I hate her so much. As to motive, the defendant contends that Colin Albert had been in a feud with John O'Keefe in the weeks and months leading up to O'Keefe's death, and that Colin Albert had thrown beer cans on O'Keefe's lawn and swore at him. There was, however, no basis substantiating these claims at the first trial. Okay. Even though we have pictures of the Alberts basically haunting John while he's away on vacation, and everybody's on his lawn and, taking selfies on his lawn and straddling his fence. But there's no evidence that the O'Keefes and the Alberts had some issues. Granted, it wasn't Colin in those photos, but it was Julie and Chris, which only makes me think that, if they have that kind of behavior, why not their kids? So it makes it very believable that Colin's a little asshole. and going around and throwing beer cans and swearing at John. I believe it. Even if there was evidence of some ill will between O'Keefe and Colin Albert, motive alone is not enough to demonstrate third party culpability. And I missed this footnote here. It says, to the extent that at an upcoming trial the defendant would offer hearsay testimony to support the claim that Colin Albert had a feud with O'Keefe to be admissible, such evidence must be otherwise relevant, not tend to prejudice or confuse the jury, and there must be other substantial connecting links to the crime. The proposed evidence does not provide a substantial connecting link between Colin Albert and O'Keefe's death. So says Judge Canoni. However, I disagree. Facts of tension between the neighbor and victim was not indicative of a neighbor's motive to take someone's life, and the defendant offered and produced no evidence suggesting that the neighbor had any opportunity to take the life beyond that possessed by any neighbor. Well, the defendant here in this case is saying that Colin was in the house. He admitted it. He testified to it on the stand. He was there. Just because a text message and Colin and his parents say that he was home at a certain time, and actually the text message doesn't necessarily say that he was home at a certain time, it just says, pick me up. And we're just supposed to believe that, yeah, he was gone at that time then and take his word for it. The lying little effer. I'll be nice. All right, so moving on. Moreover, the theory that Colin Albert is the third party culprit because he had scraped knuckles at some point after O'Keefe's death had been seen in a video drunkenly taunting others with no connection to O'Keefe and apparently was not named in police reports is speculative at best. Third party culprit theory that victim was shot by unnamed rival drug dealer was based on rank speculation and properly excluded. In Commonwealth versus Andrade, or however you say it, evidence that rival gang members lived near shooting and were involved in feud with victims was not sufficient to support third-party culprit defense where there was no evidence that they had been nearby at time of shooting in theory was speculative at best. So allowing such feeble third-party culprit evidence poses a risk of unfair prejudice to the Commonwealth and would only serve to confuse the jury. Accordingly, listen to this, evidence that Colin Albert is a third party culprit is excluded from trial. The Commonwealth motion in limine is allowed as to Colin Albert. Colin Albert is the most protected punk in Massachusetts. Judge Canoni's protecting him. Michael Morrissey's protecting him. Everybody and their mother is protecting this little shit. And if you didn't realize it before, you certainly do now. The fix is in. Protect. Oh, hold on. Sorry. Had to give my little dog a talk. I don't know what she's barking at. So the fix is in, and Colin Albert is to be protected at all costs. That's what the key takeaway is. If you didn't realize that before, you can realize it now. You can come to that conclusion now. Colin Albert is the most protected punk I've ever known. All right, so Brian Albert and Brian Higgins. As to them. As to Brian Albert and Brian Higgins, the defendant's proffer is barely sufficient, and the history of the first trial. So she's just got to throw that in there. It's barely sufficient. Like, what, woman? We have them on video taunting John and telling him to come on over and calling him outside, basically, at the end of the night. After a bunch of drunken play fighting, ass grabbing, or whatever they called it. And And we're supposed to believe that that's barely sufficient. Plus the texts from Higgins going, "You here or you coming here tonight?" And his text to Karen going, well, and things like that. And Brian Albert not coming out of the house, you know, all those things, barely sufficient. And the butt dials and all that stuff. It's barely sufficient, according to Judge Bev. And the history of the first trial casts doubt on the seriousness of the claim. So because there was a mistrial, she's like, it's very unlikely that there's any credibility to this claim because you fixed the jury. That's why. I hate this woman. I really, really hate this woman. This is why I didn't want to do this stream, and I've been putting it off because she makes me so angry. I really hate Judge Bev. However, to protect the defendant's right to a fair trial and in recognition of the fact that the defendant has no burden to prove anything under our law, the court will take the same incremental approach as it did the first trial. Defense counsel are ordered not to mention potential third party culprits in opening statements, but counsel will be allowed to develop the evidence at trial if possible, and counsel may seek an appropriate instruction if warranted after the evidence is concluded. How can you not mention other possible suspects in your opening statement? Like, that really, again, kneecapping the defense. She's awful. The court notes that the defendant at the first trial under an identical order did not seek an instruction on third party culprits. So she's saying you can seek a better instruction if you want. Though the court may ultimately exclude the proposed third party culprit evidence, she might not let it in at all, she's saying. Or counsel may abandon the theory. That does not mean that the defendant cannot offer the evidence to show the inadequacy in the police investigation, provided that the proper foundation has been established. So you can bring it all in, but only as to casting doubt on the investigation, not on any of the suspicious people in the house. What? Order. It is hereby ordered that the defendant is precluded from raising a third party culprit defense alleging Colin Albert is culpable for John O'Keefe's death. The Commonwealth motion is allowed as to Colin Albert. So the Commonwealth moved to exclude any third party stuff about Colin, so that has been allowed by Judge Bev. The defendant is not prohibited from raising a third party culprit defense as to Brian Albert and Brian Higgins at this time. So you can't even talk about it at all at this time. You have to bring it in progressively throughout cross examination. Counsel cannot mention potential third party culprits in opening statements, but will be given the opportunity to develop the theory throughout the relevant competent evidence at trial. Commonwealth motion is denied as to Brian Albert and Brian Higgins. So they can talk about Brian Albert and Brian Higgins, but not until the evidence starts to come out. So she really has not said it can come in. She's just saying you guys have to start to bring it in, naturally through your cross examination. And then I'll think about it. I'll revisit it later. She's a horrid, wretched human being. Here's some other biased orders that came in. I don't have the actual write up of them, but this one says defendant's motion in limine to allow evidence of lack of bias, which, if you remember, we read through it. It was letting the jury know this was a motion to basically let the jury know that the feds hired Arca. Well, Judge Bev denied it. So the jury will not know again who hired Arca, which, as we know, confused the hell out of the jurors. They thought that Turtle Boy or some insurance company or something hired the ARCA experts and didn't realize that they were completely completely independent and hired by someone else. And that also prejudices Karen in, when Adam Lally was like, "Well, would you have changed your decision if you knew that there was a hair and DNA on the bumper?" Like, well, no, it wouldn't, but also it doesn't matter because and you're prejudicing the defendant there because they're not the ones that gave the information to ARCA. It was the feds. The feds got information from both the defense and from, well, what they could from their own investigation and gave it to ARCA. The Commonwealth wasn't cooperative with the feds. So I'm sure maybe if they had been, or maybe if they weren't under investigation themselves, maybe they would have had more knowledge of what was going on with feds, but they didn't. So there's that. All right, so the next motion that also shows bias. Again, I don't have her order, but the defendant's motion requesting audio access to sidebar conferences during voir dire. If you remember this, Karen Reed, oh, I think it was Alan Jackson who had argued this for Karen Reed at the motions hearing, the latest motions in limine hearing. What they were asking so that she didn't have to keep getting up and down and up and down, and she has medical issues. She doesn't want to get up and down every single time with the attorneys, and it also there was an appearance of does it look weird to the jurors or the potential jurors, and she wanted audio for not just the trial but for jury impanelment so she could hear what was going on during jury impanelment. This freaking bitch, which is like the nicest thing I can call her, denied this for no reason. Just denies it. The defendant is entitled to be present at sidebar during impanelment all stages of trial. No additional accommodations are necessary. Denied. This is an American Disabilities Act violation. Karen Reed doesn't need to be getting up and down every 5 minutes. And if she wants audio, even if she was hard of hearing, just asking for audio assistance because you're hard of hearing should be without a question allowed. Like, why is this even a question? Why would you deny this? Other than the fact that you are just being a vindictive bitch. That's all. Like, I can't think of anything else. She hates Karen. She hates Karen's attorneys, yet she refuses to recuse herself, and this is what she does. Just deny everything for the defendant and help the Commonwealth in every way she can. It's outraging. It makes me outraged. Let's move on to the Commonwealth. So we're done with the orders. So now we're going to move on to Commonwealth motions. The Commonwealth's motion for parameters of jury impanelment. The court previously allowed the Commonwealth's motion to check the criminal histories of all 16 prospective jurors to determine whether they are qualified to serve before the jury is sworn. The Massar Crim P 20 outer time limit for the exercise of preemptory challenges is before the jurors are sworn. Challenges for cause to be made before the juror is sworn to try the case. The Commonwealth will produce any Corey records, those are the background checks, to defense counsels. So the Commonwealth is going to do the background checks and then provide them to defense. In the principles of fairness and equity, the Commonwealth inquires of what ground rules or restrictions are in place regarding either party from conducting extraneous inquiries into the qualifications of a potential juror, including internet or social media searches. So they're looking at your background, they're looking at what you're posting. So anyone posting on this case in one way or another will not be making it on the jury. The Commonwealth moves for clear ground rules and boundaries and asks this honorable court to advise both parties. And I assume she did. I know she had some more instructions the very first day of jury impanelment. Um, but I don't remember how she addressed that. Um, I know they are allowed to do the inquiries. I'm sure she's allowing them to do, internet, social media searches and things like that too, as part of the background search. Up next, Commonwealth's motion to impound exhibit in support of Commonwealth's motion to compel reciprocal discovery of ARCA witnesses or to exclude their testimonies. The Commonwealth moves pursuant to the Trial Court Rule 8, Uniform Rules of Impoundment Procedure, that the attached supporting exhibits to its motion to compel reciprocal discovery of ARCA witnesses or to exclude their testimonies be filed under seal and impounded. So we never even saw the filing. So this is just a filing to let us know that there was a filing and an exhibit, and those were filed under seal. The Commonwealth's exhibits contain references to confidential federal documents which are restricted by the Federal Protective Order. The Protective Order does permit disclosure to the Norfolk Superior Court for use in its criminal proceeding, provided that the court authorize the sealing and impoundment of the records. The Commonwealth moves for the exhibits attached to its motion to be impounded. I'm sure she did because we never saw them. So. And no, we got two more from the Commonwealth. This one is a motion for larger screen in the courtroom. Now comes the Commonwealth and respectfully requests the court allow for a larger screen in the courtroom or alternatively a second screen to the side of the witness stand that would allow jurors to better see admissible evidence or chalks that are being projected onto the screen by the computer. This is actually, I think, um, a good filing from the Commonwealth because there were a lot of jurors that complained that they couldn't see the screen. It was too far away. Even people in the gallery were saying that they couldn't see. So it's a good thing if they get a bigger screen or a second screen. Enlarged photographs are clearly admissible if they are sufficiently verified and fair representations of the subject matter and aid the jury in understanding the issues. This might help them see the Sally Port and the ring camera video of Karen hitting John's car better too. So think of it this way. So they might be able to see exculpatory evidence much better. All right, so Commonwealth versus Sosa parties should explore the viability of admitting excerpts of voluminous video recordings pursuant to Mass G evidence, whatever statute, particularly where a jury may find it difficult to master the technology necessary to find and view the relevant parts of the complete videos from the jury room. So when they're in the jury room and they're in there deliberating, if, there's a lot of things, it's easier, it's better to do it, um, introduce those things easily and most conveniently so that everyone can see them. The Commonwealth agrees to assume the costs of the larger screen and/or secondary screen and asserts that the technology would be used to merely display admissible evidence or chalks to assist the jury. She's going to allow this, yet she denies Karen's audio. But she'll allow this, guaranteed. Like she's going to be like, "Oh, sure, Hank, whatever you want." Alternatively, the Commonwealth moves for permission to provide jurors with their own physical copies of certain admitted photographs or chalks to use in the courtroom while witnesses testify to assist the jurors in understanding certain testimony. So we'll see what she says on that. I predict she's going to say aloud. Commonwealth's renewed motion in limine to exclude expert testimony of Garrett Wing. If you remember, we went over Garrett Wing before on my channel. Attorney Melanie Little, has her own YouTube channel. And before the first trial, she had this expert on named Garrett Wing. He trains dogs how to properly bite in situations when you need a dog for those situations where you need a dog to bite, like when they're chasing down a perpetrator or whatever. So that is, he talked about in length about the dog injuries, and he showed us his own images and things like that. He had like these prosthetic arms that they would use during their training, and you could see the marks that the teeth made, and they look almost identical to the kinds of marks that were on John's arm. So he's going to be testifying, supposedly, if he's allowed, for the defense, obviously, to talk about the dog bites. So the Commonwealth, this is the first time they asked to renew Garrett Wing or to exclude Garrett Wing. They said they didn't have of the any of his reports or anything like that. So they didn't have the discovery, which they fixed that. The defense handed over all necessary discovery. So now Hank's got some more complaints about Garrett Wing, and they're completely inaccurate too. So now comes the Commonwealth in the above captioned matter and respectfully requests this honorable court exclude expert testimony based on a violation of Rule 14 and the defense's presumption that they are entitled to rebuttal expert testimony. So he's saying, or he's assuming in this case, that Garrett Wing is going to go on as, or that the defense had planned to put him on as a rebuttal expert. So rebuttal would be like there's your state's case, the state has their case, and then the defense puts on their case. Then the state has a chance to rebut. The rebuttal would be if the defense had a chance to go after the state's rebuttal. However, they're saying that that's what this is when they were planning to bring Garrett Wing, but we know that that's not true because they address this in the next motion that we're going to read. So on March 25th, 2025, the Commonwealth received a 24-page report of Lieutenant Garrett Wing, who he's former law enforcement, so that's actually really good for Karen. Report of Lieutenant Garrett Wing, a suggested expert in dog training and dog bites. The defense proffers Mr. Wing as a rebuttal witness. That's entirely false. They do not. As a rebuttal witness to the Commonwealth's Dr. James Crosby, claiming that Dr. Crosby's conclusions are flawed and incomplete. However, as previously disclosed to the court and defense, the Commonwealth does not intend to call Dr. Crosby in its case in chief. The Commonwealth intends to offer Dr. Crosby only if necessary to rebut the testimony of Dr. Marie Russell. Okay. What do you mean only if necessary uh, to rebut Dr. Marie Russell's testimony? You know she's going to say things that aren't going to be good for your case. So you know you're going to call this goofball who shouldn't even be allowed to testify in this trial. He is a dog behavioral specialist. So there's that. What he's doing talking about dog bites in a trial, I don't know, but that's what he's doing. There is no sub rebuttal in Massachusetts, says Hank. I don't even know if that's true or not, but it doesn't matter because the point is they're not planning to put him on as a sub rebuttal witness. Remarkably, the defense's own proffered expert has rebutted certain opinions of Dr. Russell. Mr. Wing has publicly stated that Mr. O'Keefe's arm injuries were in no way attributed to paw, claw, or stretch marks, and that it would be very rare for a dog bite to be a puncture wound, where 99 out of 100 times dogs cause lacerations, not puncture wounds, particularly when a dog is untrained. Never did I don't think, correct me if I'm wrong, but I don't think that Marie Russell said that there were actual puncture wounds on John's arm. In fact, I think she calls them punctate wounds, which is different. It's like a puncture and a tear, I think, type of a wound. But don't quote me, I don't know what I'm talking about, but something like that. Like she calls it something else. It's totally technically medically different. So for him to say that puncture versus punctate or whatever. Like, they're not, these two witnesses aren't contradicting one another. That's not what's happening here. You're just really not that bright, Hank. Further, the defense has also objected to this line of testimony, stating that a jury should not hear from a dog behavioralist on what the cause of the wounds to the right arm of the deceased to of what the cause of the wounds to the right arm of the decedent. Sorry. My brain just mixes up words. I think, and I looked this up. I don't know if you can like develop dyslexia at a later age. You kind of can, but it's not really dyslexia, but I think that's what's happened to me. My brain has just like it mixes words on the page for me. So I apologize for my slip ups. I try hard not to do that. The trial judge has substantial discretion in determining whether to allow the presentation of rebuttal evidence. Under the Massachusetts Rules of Evidence, the trial judge generally has discretion to permit the introduction of rebuttal evidence. However, there is no absolute right to present rebuttal evidence that only supports a party's affirmative case. If permitted by the court, the Commonwealth's intention to call Dr. Crosby would be a legitimate and appropriate response to the defense's case and relevant to rebut the defense's claim that the victim's injuries were substantiated by a dog attack. Rebuttal is legitimate when it responds to the opponent's case. At any rate, the judge, as the controller of the trial, has a nearly unreversible discretion to allow it. Commonwealth's rebuttal evidence relevant to rebut defense witness testimony about suspects' whereabouts. The defense's position that they would then be entitled to call Dr. Wing to rebut the Commonwealth's rebuttal is unfounded and not appropriate under Massachusetts law. Keep talking, Hank, because you just sound really stupid because they never said that he's going to be a rebuttal witness, a sub rebuttal witness. The defense may not present one theory of causation in her case in chief, as a matter of fact, present a different theory of causation in rebuttal, nor may the defense offer evidence that merely supports her own claims in rebuttal, especially when the defense is aware of this proffered opinion prior to trial and could present it as part of her case in chief. Oh, good, Hank, I'm glad you said that because she does want to put it in her case in chief. She does. So I'm glad you brought that up. I'm glad you said that because you're wrong. You wrong, Hank. For the aforementioned reasons, the Commonwealth's motion to exclude expert testimony should be allowed, as the defense is not entitled to rebuttal testimony, especially where the proffered opinion of Mr. Wing is solely to support the defense's own claims in its case in chief. Well then, what does the defense have to say about that? Now comes the defendant, Karen Reed, in the above captioned matter and respectfully requests this court to deny the Commonwealth's renewed motion in limine to exclude expert testimony of Garrett Wing. And we've got a footnote here. It says, defendant does not waive and reserves any argument put forth against Commonwealth's original motion in limine to exclude expert testimony of Garrett Wing. The entirety of the Commonwealth's renewed motion appears to be based upon the inaccurate premise that the defense intends to call Lieutenant Garrett Wing as a rebuttal expert to the Commonwealth's expert, James Crosby. In actuality, the defendant intends to call Lieutenant Wing as an expert witness in her case in chief and not a rebuttal witness to Dr. Crosby's testimony. On this basis alone, the Commonwealth's motion should be denied. As the defense has stated previously, on June 18, 2024, this court determined that only a medical doctor could opine on the medical cause of an injury to a human. That's what Judge Bev's words were, her own exact words. Until March 6, 2025, the defense therefore operated under the impression, this is genius writing, operated under the impression that only medical doctors are able to testify as to the medical causation of an injury to humans, including injuries caused by dog bites and or claw marks. This court's March 6th, 2025 order, you know that one where you let James Crosby opine on dog bite injuries? That one, a dog behavioralist? Yeah, that one caused the defense to revisit the topic of the wounds to the right arm of the decedent, including potential witnesses expert in dog inflicted wounds on humans who are not medical doctors. Bam. You did this to yourself, Judge Canoni. You just put yourself in a very tricky spot because you allowed Hank to get whatever he wants. So now you got to make a decision. Do you overrule yourself on James Crosby, or do you continue to make it look like you are a complete buffoon and not let this doctor opine, or not like this expert opine on dog bites? Because isn't that like apples to apples now you're comparing? You have a medical doctor who's the gold standard of identifying injuries to a human, but then the Commonwealth wants to bring in a dog behavioralist instead. So we're going to match your dog behavioralist, and we're going to have our golden standard and our dog behavioralist to wipe out your your Dr. James Crosby. It's a brilliant move. Brilliant. I love how they're throwing it back in Judge Bev's face, the order that she made, as they should. She's not playing fair. So they should be calling her out on this. At no point did the defense ever express that Lieutenant Wing is intended purely as a rebuttal witness to Dr. Crosby, rather that the court's determination on Dr. Crosby, including the defense's motion for reconsideration of the March 6 order, would inform defense strategy regarding Lieutenant Wing. So basically, you, Judge Bev, changed our strategy by making that motion. So thank you. Thank you for ruling that way because now we're going to bring Garrett Wing in. This is beautiful. It's beautiful. Additionally, until the March 6th order, several questions remained about how the defense would proceed relative to the Commonwealth's treatment of Dr. Crosby. At oral argument on March 4th of this year, the Commonwealth verbally stated that it did not intend to call Dr. Crosby in their case in chief and intended only to call him as a rebuttal witness against the testimony of defendant's expert witness, Dr. Marie Russell. The court asked, "So, just to be clear, the Commonwealth does not intend, if I permit the testimony, does not intend to call him in your case in chief?" The Commonwealth responded, "Absolutely not." The Commonwealth renewed motion. Sorry, that's from the Commonwealth's renewed motion. However, the court's March 6th order contained no such limitation on the scope of Dr. Crosby's testimony. Again, Judge Bev, you did it to yourself. No such limitation on Crosby's testimony for the Commonwealth to call him only as a rebuttal witness. So, that's another good point. She didn't put a limitation in that order where she allowed him to testify that he can only testify as a rebuttal witness. So just because Tank said he's not going to do it doesn't mean that he's not. And we know far too many times that he has lied in this whole situation. So I don't believe a word he says. If he says he's not bringing them in, I think he's absolutely going to ambush and bring Dr. Crosby in his case in chief. So they should be prepared to have Garrett Wing and Dr. Marie Russell on board. Nothing wrong with that. Due to the lack of memorialization of the Commonwealth stipulation, the defense reasonably assumed that the Commonwealth could call Dr. Crosby in its case in chief should it choose to. So there's no limitation. You didn't put any restrictions on Hank. So if they want to, they can. For the first ever time in writing, and after receiving the report of Lieutenant Wing, in its renewed motion, the Commonwealth states that it intends to offer Dr. Crosby only if necessary to rebut the testimony of Dr. Marie Russell. like I said, you know you're going to call him. The defendant intends to call Lieutenant Wing as an expert witness in her case in chief. Lieutenant Wing, Lieutenant Wing's decades of knowledge, skill, training, and experience together with his documented methodology qualify him on the subject of dog inflicted wounds on humans. To cure any perceived complaints by the Commonwealth with Lieutenant Wing's original report, the defendant will provide the amended report of Lieutenant Wing, which will remove all references to Dr. Crosby. The defense expects to provide this amended report to the Commonwealth within the next 5 calendar days. As the defendant intends to call Lieutenant Wing as an expert witness in her case in chief, the discussion of law on page 2 of the Commonwealth's renewed motion is inapplicable. The Commonwealth renewed motion at 2. This notwithstanding, and in reference to the Commonwealth's incorrect assumption that the defendant intends to call Lieutenant Wing as a rebuttal witness to the testimony of Dr. Crosby, the Commonwealth states in its renewed motion that there's no sub-rebuttal in Massachusetts courts. This statement is accompanied by no authority and it is correct. So even if we did want to call him in our sub-rebuttal case, we could. There's nothing stopping us. So get bent, Hank. Allowing surrebuttal witnesses, the judge limited Houghton to one surrebuttal witness only. Again, allowing surrebuttal witnesses, on surrebuttal, Brown testified that 2 Walkmans were returned to him after his arraignment. In fact, expert witnesses are explicitly allowed to testify in surrebuttal in Massachusetts. A defense surrebuttal expert who claimed the same test results reached a different conclusion and testified that Brown was not malingering. The defendant was allowed surrebuttal by a psychologist who sought to undermine some of the premises on which the Commonwealth's expert had relied in reaching his opinion that the defendant was criminally responsible. Therefore, even if the defendant did intend to call Lieutenant Wing as a surrebuttal expert, there is no Massachusetts law the defense could locate that would prohibit her from doing so. So there's Hank caught in yet another misrepresentation to the court. In a court filing now this time. So that's kind of good that they caught him there. All right, so indeed, there is contrary law in favor of the issue. So not only is it that there's no law, but there's law that supports our position. So you wrong again, Hank. For the reasons set forth herein, the court should deny the Commonwealth's renewed motion in limine to exclude expert testimony of Garrett Wing. The defendant intends to call Lieutenant Wing in her case in chief, not as a rebuttal witness. As the court's March 6th order allowing Dr. Crosby to testify as an expert, experts are no longer required to be medical doctors to testify about the medical causation of the injuries. You said it yourself, Bev. Lieutenant Wing's decades of knowledge, skill, training, and experience together with his documented methodology qualify him on the subject of dog-inflicted wounds on humans. Finally, and in the alternative only, surrebuttal witnesses are allowed to be presented in Massachusetts. For these reasons, the court should deny the Commonwealth's motion. That was written by Alessi. That was beautiful. Beautifully written. I loved that. Okay. That was like the big one that I thought was really important to go through. But we have just a couple more things. These are going to be really quick. So, well, this one's actually a little longer, but the rest of them are quick. So, this is the defendant, Karen Reed's emergency motion for relief from this court's March 31st order impounding the clerk's list of jurors. So, that was the order where it was all combined. She had the stenographer on one plus, impounding jurors' names and whatnot. So, this is their response to that. So now comes Karen Reed, the defendant, in the above captioned matter and respectfully moves this honorable court for relief from its March 31st, 2025 order to impound the names in the clerk's list of jurors for Norfolk County. Ms. Reed asks for this list to be released to her legal team with the understanding that this information is not to be disseminated to the public. Ms. Reed and her legal team will abide by any protective order imposed by the court. As grounds for this motion, pursuant to the statutes, Ms. Reed and her counsel are statutorily entitled to this list. Ms. Reed agrees that in a high-profile case such as this, good cause exists to impound the jury names from public access, but there are no such grounds to prevent this list from being released to Ms. Reed and her legal team. She needs to know who the potential jurors are. Both cases cited in the court's order, Commonwealth versus Fahuda or something, I don't know, and Commonwealth versus Vines, pertain to post-trial impoundment of juror names, and neither involved preventing a defendant and her counsel from assessing juror names during impanelment. As you can see, this was allowed by Judge Bev the same day. Furthermore, Ms. Reed's ability to review this list is even more vital given the high profile nature of the case, as more efforts are required to determine if jurors are truly fair and impartial. The Commonwealth requested query checks on jurors due to its apparent unwillingness to take jurors at their word regarding their criminal records. Similarly, Ms. Reed is requesting juror information in an effort to determine exposure to the case and potential biases. Wherefore, the defendant respectfully requests that this honorable court immediately allow this motion. It is allowed, as stated by counsel. The information is not to be disseminated to anyone. It's for counsel and the defendant only. So, that was allowed. It also appears, and I don't know what this means. You can take it for what it is, but it appears that on a daily basis now, the defendant is filing this exact identical motion, only with a different date at the top. So here it says, now comes the defendant, Karen Reed, Ms. Reed, or defendant in the above caption matter to request the updated clerk's list of jurors for Norfolk County. So she's formally having to request the list of the jurors for each day of impanelment. Ms. Reed asked for this list to be released to her, her lawyers, a jury consultant, and 2 law clerks who are working with Ms. Reed's team. And this has been a daily occurrence that they have been filing these. So it makes you wonder if maybe the jury list is not getting to the defense right away, or if there was a problem in the beginning. People are speculating. So I don't know. Take it for what it is. Maybe it's just to protect themselves. I don't know. But it's odd. And it's extra busy work, you would think, because they should be getting the list anyways. And finally, our last update is Karen Reed is going to the top federal court. So she went to the SJC again with a brand new motion. They denied it, said you can certainly appeal to the First Circuit Court. She did. They denied it. And now she is going to the Norfolk County Superior Court. Nope, that's not right. The Supreme Court of the United States. Sorry. She's going to the Supreme Court of the U.S. And it's called a petition for a writ of, I don't know how to say that, to the United States Court of Appeals for the First Circuit. So a writ of cert. It's basically, will they hear her argument? So that's all that is. So she is appealing. They're going to ask and see if the federal court will hear her argument. I really think that there's some precedent here that could be set as to you need to be better at explaining jury instructions. I think the problem here is Judge Bev, and that's what nobody wants to be willing to say on paper. But she's a problem. And she's part of a big reason why those jury instructions were so confusing. And they didn't really lay that out in their appeals originally, just that, instructions might have been vague or whatever. But I really think that they needed to hone in on the fact that Judge Bev is trying to sway a certain outcome by not putting not guilty boxes and whatever else, by making her jury instructions very vague and not explaining what to do in the event that you have a split verdict. She never explained that. And usually there are standard instructions for when you have multiple charges, what to do in the situation when you have a split verdict. She didn't read the standard instructions for that. She read standard instruction for single charges, not multiple charges. And I really think that that is a huge problem. I really think they need to go back and revisit the jury instructions because this is the precedent that would be set is make sure that your jury instructions are clear and that people know what to do in a situation where there might be, multiple verdicts, a split verdict. They That's part of the problem here, and I think the federal courts should be providing guidance on that and also whether or not to question them at the end and say, is this or is this not your verdict? And, were you able to reach a verdict on anything? Maybe those things need to be standard protocol in court. I don't know. I'm just saying that these are the kinds of things that the federal courts like to look at to set precedent. But again, it's been denied multiple times now. Is a federal court gonna be like, well, no one else seems to think that anything went wrong, so let's just keep on keeping on? I don't know. You guys tell me what you think her chances are of a federal appeal being heard, number one, and number two, allowed. Will a federal court hear her appeal and then also either allow the make Bev, I guess, do some kind of inquiry to the jurors, or do you think they'll just drop the charges outright? I don't know. I don't think they'll do that, but maybe it would set a tone if they have an issue with what they're doing to Karen Reed. That might be a good thing. It might be a message. Send them a message. Drop all the charges, or drop charges one and three, and then see what the Commonwealth will do. You know, I That's what I would do if I was a federal judge, but that's why I'm not a judge because I don't think that's legal. But anyways, let me know what your thoughts are in the comments below. Please don't forget to hit the like button and I will see you guys in the next one. We have more episodes coming because this wasn't even all of the things that happened this week. So we also had multiple filings from going to federal court of people possibly suing Bev and Norfolk County and certain officers for the buffer zone craziness that is happening over there right now already. And we also have some updates on Turtle Boy. So I have some additional episodes in addition to this because there was just so much this week. You can see why I procrastinated because there was just a lot and Judge Bev gets me angry. So, how does Judge Bev, God, I can't talk. How does Judge Bev make you feel? Let me know in the comments below, and I will see you guys in the next one. Take care. Bye now.